then you can come back up and you'll have your 5 minutes to make a rebuttal.
Yes,
Okay?
sir.
All right.
Yes, sir.
Do you have any questions about anything? Anything you don't understand?
No, Your Honor, I don't.
You
Okay.
understand that today, we're not going to render a decision. We will take the matter under advisement, we'll read the record, we'll do the research, and we'll write an opinion and send it to you.
Yes, sir.
Okay?
Yes, sir.
All right. You ready to proceed then?
Yes, sir.
Okay.
May it please the court. My name
Yeah.
is Heather.
One more thing before you get started.
Yes, sir.
Watch the lights.
I am.
Green light, yellow light, red light. Green light, as long as the light's green, you've got plenty of time. Yellow light means you're running out of time, and the red light means you're out of time. Okay?
I'll stop.
All right.
Ms. Harris, you've been here before, haven't you?
Unfortunately, I'm thinking to remind the court of when I was last here.
And you were pro se the last time you...
Yes, Your Honor. Yes, I was.
Okay.
Yes,
Well,
sir.
Judge Armstrong's got a better memory than I do.
Okay. My name is Heather Patrice Hogerbrooks Harris. I am here representing myself. I want to begin my arguments with addressing the two defenses in the appellee's brief. The first is the claim that I have no standing to have objected to the will that was admitted to probate. I want to remind this court that I was here, unfortunately, in this court in W 2016-01768. Opinion by this court was filed on February the 10th of 2018, and the mandate was issued on February the 15th of 2009. Unfortunately, because of testimony of the sole heir in the Henry estate of Louise Green, I had to come to this court. That court looked at a will that had nothing to do with me. I was not a signatory to it. I was not nobody I knew was a signatory to, and it had to rehabilitate that will. In that will, my husband, on that will, Henry estate of Jimmy Harris, names me as a residuary beneficiary. And therefore...
How does that help you here, Ms. Harris?
Well, that helps me here in that the court, the probate court, and the appellee's position was that if I wasn't a named heir in the will they were attempting to probate, then I did not have, let me explain, as I understand, if with that will being intestate, as opposed to, unless I could show that I would have an interest if it was intestate, then I had no say in it. Well, all beneficiaries, my understanding is, as a residuary of estate, if Mrs. Green's will was indeed intestate.
I mean, if she had no will.
If she had no will.
If she had no will, would you be an heir? Would you be an...
If she had no will, I may not be an heir, but all beneficiaries are not heir. If she had no will, I would, as I understand it, I would be able to take per stipes pursuant to her son's, her biological son. She also has adopted sons, residuary, being named his residuary. And as I understand it, the residuary would take...
So are you arguing that that language, per stirpes, would cover you as a wife of the deceased?
No, it would cover me as a residuary in my husband's will. It would cover any person that he named as a residuary, as a beneficiary of that will. If, in this case, where he has predeceased, if there was no will, that will would then proceed pursuant to intestate succession laws of the state. And therefore, in lieu of his presence, there would be a stand-in. And usually that stand-in would be an heir, and maybe then, in this case, it would be his daughter and his son, who is not noticed here. But in my case, since I am his residuary, it would cut that off. I would then take. That's my understanding. Certainly, I have searched y'all's cases. I could not come up with that exact scenario being offered there. However, I have experienced that exact scenario. But yeah, that's.
Let me ask you one other thing. I mean, why do you even care about this will being admitted to probate to the extent that it does not affect title to any property?
But it does, Your Honor.
How does it do that?
It does that because.
It's not admitted as a monument of title.
But it's been used that way, Your Honor. If the court has read this record, it is absolutely been used that way. And it was meant to be used that way. The first, and that's a question I've made a question. Is the proof of a will any different than if it was a mirrorment of title versus a regular form? My understanding is the proof in proving the will should be the same. So if I had an interest that I indeed filed objections on when it was being admitted as a monument of title.
But it wasn't admitted as monument of
But it was submitted there, and it was only not admitted there because of direction of the judge. But if I may, Your Honor, get to your point, there is a separate statute that I mentioned in the brief. That statute says that that will admitted to probate in, I lose the words, whatever form, solemn form or whatever, is evidence of the ownership of the property. So it started a big old, it starts there is a statute. I think I put it in here. I found it, but and that was the point of the use. I argue that to come out of a quiet title action that had to be filed through a whole bunch of changes. This has been ongoing for 3 years. Note that this property was not, no taxes were paid on this property since 2014. So, and to come then in the middle of this quiet title matter, and that you did not say, well, I have a will with regard to that. What you've done is go back and you craft something to collaterally attack what's going on in that. What I attached in the record, because I don't ever believe that anybody listens to me, was documents. Documents to show that there's a problem with the signature on the will. Documents to show that there's problems with the notary on the will. From 2012, the sole heir, unbeknownst to ownerships, at least of one of these properties I know, transferred properties into her name, into her and my husband's name. He was devastated. One of the properties, the Fernwood property, when that owner learned of it, he and that owner, we're in the midst of cancer treatment, had to get that straight or try to get that straight. And you'll see there's just so much transfer because of the heir. So the way they did this is to specifically get around looking at what could be considered a lot of fraud in this state. I also brought to bear that in this case I mentioned, there were 2 other people noticed. There was a proponent of this will, my husband's daughter, from a marriage. There was also noticed a young man that my husband has always acknowledged as his son from a high school sweet situation. So it's just wrong, and I don't think there's any other way to look at it than it being wrong. The second point I want to cover quickly is that there's a claim that I was noticed for this. I was aware of the filing. I did file a response to it, and in my reply brief, I indicate the last communication I had with regard to Mr. Branch and that was on March the 16th. I think I read in the transcript that it is claimed that that notice was given on the 16th of March. I don't know. It didn't discuss what form that notice was in, and from my reading of the transcript, I doubt that the court was concerned about it, but I didn't get it. But even if there was the 16th, 24th does not give 10 days of notice. So the notice was defective. The notice was non-existent. The procedure was grossly unfair. The transcript is a walk of the judge, I think, stepping over to advocacy. My argument, if we just look at it and we just read it, and I think anybody who wants to condone that, my time is up, and I'm finishing my rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Thomas Branch. I represent the estate of Louise Shipley Green. At its heart, what this case is about is whether or not Mrs. Harris, the appellant, had standing to contest the last will and testament of Louise Shipley Green. She does not. I'm not sure what, her being a residuary beneficiary of her husband's estate has to do specifically with this estate. I don't think it does. Her husband, Mr. Harris, died March 10th, 2015. Mrs. Green, who's the decedent in the proceedings before us, died July the 11th, 2016. Any kind of interest that her husband would have had in this estate lapsed upon his death. If she was successful in proving that this will was produced by fraud, or if the signatures were fraudulent or anything of that nature, the only thing that would have happened would have been that will would have been set aside, and at that point, the estate of Louise Shipley Green would have been an intestate estate. The only beneficiary that could take from that intestate estate is her granddaughter, Tiffany Harris, who is the executor of Miss Green's will and the only surviving beneficiary. As far as the notice goes, you will see in the record that a notice of hearing was filed, whereby it was sent to the appellant, Mrs. Harris. Even still, if we read the transcript, what is evident that, number one, the judge did consider her sworn objection to admission to probate the last will and testament. However, what she based her ruling on was the fact that the appellant did not have standing to contest the last will and testament. Again, at best, if she was or would have been successful, the only thing that would have happened would have been that Tawana Harris, who was my client, who is the executor of the estate, she's the only heir at law before the court. With that being said, I really do not see how this body or this tribunal could disturb the ruling of the probate court. Naturally, I deny any bias from the trial judge. Naturally, I've appeared before her a number of times, and she has always been a straight shooter. She's ruled against me, and she's ruled for me. One of the consistent things in her rulings, though, is I've always believed she followed the law. With that being said, if this decision is disturbed and overturned, it'd be a waste of time and judicial economy, because the only thing that would happen at best would be that my client, Ms. Harris, Tawana Harris, the executor of the estate, would be declared as the only heir at law. That is the only evidence before this court. It would be different if we had another will signed by the decedent, we don't have that. If it is set aside, it becomes an intestate estate. And again, even in those proceedings, she has no standing. Thank you, Your Honor.
Let me ask you, in connection with the property that Ms. Harris complains about, how does the admission of the will to probate affect that property?
It can affect that property. It was initially filed as a monument of title, and I can say, and it's not before the court right now, there was a proceeding filed in Chancery Court a little bit before the proceeding filed in probate court. I did in the proceeding in Chancery Court sued Tawana Harris, which is the beneficiary of the estate, and I did represent her in those proceedings filed upstairs. Sorry, I was about to say upstairs at Chancery Court. In those proceedings filed in Chancery Court. Those proceedings got dismissed, and the reason that they got dismissed was the same reason why basically her sworn objection got dismissed in this case. She didn't appear to prosecute her case. To the extent that it affects disposition of the property, it can, and it does. It does. And again, this isn't before the court, but the reason I believe that Ms. Harris filed that proceeding in Chancery Court was that there was an affidavit of heirship filed whereby Ms. Harris declared herself to be an heir of the decedent, Mrs. Green. In the Chancery Court proceedings, those affidavits, I shouldn't say those affidavits that were filed, but her action basically I think she filed an action to quiet title. That was dismissed. A subsequent action has been filed in Chancery Court by me on behalf of Mrs. Harris, basically to set aside the affidavits of heirship that she filed. One of the things that this court, I'm sure, is aware of, when you file an affidavit of heirship, you have to make a statement in your affidavit basically indicating that there is no last will and testament by the decedent from which you're trying to get the property from. In this situation, there is a last will and testament, and it's currently pending in probate court. I hope that answers your question.
What was the reason for the delay in admitting the will to probate?
I'm not sure. When you say the delay in admitting the will into probate, the minute I heard, the minute my client came to me in reference to the action that was filed in Chancery Court, she did advise me that there was a will out there. The minute, I came into possession of that will, I filed the action in probate court to have that will probated. One of the things I did do when I did, and I'm not sure if I said this, I probably did, I'm not sure whether or not I said this before. When I did institute that action in probate court, I made sure each filing that was filed in probate court was also filed in Chancery Court, so that basically both judges knew or had an idea what was going on in the other court.
But the petition to admit the will to probate was 6 years after the decedent passed, is that right?
Yes. I don't have an explanation for that. I do not have an explanation for that. The minute, I can say that the motivation for my client coming to see me to have that will probated was that there was an action filed in Chancery Court. To that extent, I cannot explain why she waited 6 years, other than the fact, I'm not sure whether or not she knew that she needed to have the will probated in order to pass title to the property or do whatever. But again, that's my speculation. I mean, I've represented a number of clients that have taken their time filing last wills and testaments. I've ran into the excuse of we didn't know that there was an asset out there, or we didn't know we needed a will to be filed to actually have the legal consequences of a will, because as I tell everybody, that I represent, a will does not speak after the death of the testator unless the court says it can speak by virtue of instituting an action in probate court.
Thank you.
Thank you, Your Honor.
If I may, Your Honor, I absolutely believe there should be an intestate estate. What you find in that record too, or because there is adopted brother, public records say Mrs. Green had adopted son, Sean Darius Green. Now, when I first received pleadings that the county was regard to tax sales, this was 6 years of non-payment. My first reach out was to Mr. Green, who lives in St. Louis. He came down. We did the affidavit of heirship together. And we remained together through a while until he disappeared. He spent money. He spent at least $3,000 or $4,000 of his own money because we had to rehab these places. You know, they were just left derelict and left abandoned where their houses was. But for some reason, we were set to close on the Alsey property, which would have paid the taxes, and he just didn't show up. And after 3 or 4 months, nothing happened. But he is, you know, a non. If it wasn't, it should be open. Because the people who are being crafted out of it that should be notified, Mr. Green and Mr. Heron, they would be notified. This has not been, you know, I wasn't looking for this, you know, but it fell in my lap, or it fell in my, you know, I just felt that this was not a way that somebody ends their life. You know, I looked at my husband's DD 214 is from the 1771 Alsey Street. That's almost 60 years ago. And I don't think anybody, there's too many questions, and I'm looking at my time, and there's much need to be said, but there's too many questions regarding the legitimacy of this will. First, Mrs. Green died in 2016. There's been no taxes paid on this property since 2014. None. I didn't jump in here to do this, to take this over. I jumped in to prevent these properties from being sold at a tax sale, which I think it's just not, you know, it's an unceremonious way to end what was, at least for those people I know, a major accomplishment. And I did so with the brother. I did not learn how involved or how messed up the transfers, multiple transfers in this record until luckily I had a Chapter 7 that still had an adversary proceeding open. When I found that there's thousands of dollars in taxes and fines due, and my adversary proceeding was open in 2017. These taxes go back to 2014. There's provisions in the bankruptcy code for like 2 years of taxes. I filed over there, and it was in talking to the trustee and sitting down with the trustee and Mr. Knoll from the tax assessor and Mr. I don't remember his name from the city, that we see how convoluted this property is. How many transfers, unauthorized transfers back and forth in a short period of time. And let me sum up by saying this. You're the big picture people, and y'all are a lot smarter than I am. These taxes were not paid. All of a sudden, this will, when we got a public record that shows that she has more heirs than Mrs. Harris, who didn't do anything for these properties for 6 years. Ignored all notices, paid not a copper penny. And all of a sudden now, she is crafting, we're gonna impose this very crafted will that has a questionable signature, that the public record is questionable, contradicts what they say. I think that would be suborning of deceit, suborning of dishonesty, to be that myopic. And in finalizing, yes, intestate action would provide me, I would take, and it would also allow there to be investigations and allow the will to be challenged. And that's my time, and thank you for your attention, Your Honor.
Thank you. Thank you. Thank you, folks. We will take this matter under advisement and attempt to get you an opinion at the earliest possible date. I believe that concludes the call of the docket for the morning. We'll be in recess till the call of the docket till this afternoon.